Let's look at the contents. Part 1 is the problem. Unintentional harm. Part 2, lessons from Pioneer's trials, learning from abroad. Lack of ministerial responsibility. That's a huge one. Part 4, proposal is, however, quite optimistic. They call it a win-win. Win-win, my ass. One family, one judge. Yes. Enabling alienating behaviours. Of course it enables alienating behaviours. Unnecessary separation. Harm to parents. Mental distress. Hostility promoted. Handling accusations of domestic abuse. Parent A is unjustifiably cut off from seeing the other child by parent B. By the time parent A can show they're innocent, the court may then order that the status quo is maintained. I'm going to try not to swear here. Let me finish reading it. Almost any judgment can be justified by claiming it is in the best interest of the child. It's disgusting. I'm glad this is highlighted here. Ladies and gentlemen, mums and dads, children of appropriate ages, welcome to a solo edition of the Family Court Voice, where I'm hoping to bring to you different topics throughout the series, where I aim to share a little bit of thought leadership. The thoughts and views are completely my own. So following on from the podcast that we had with Michael Love, better known as Deadbeat Dad Bod to most of you, he brought up the APPG report, and I promised him that I would give it a read, and I thought it might be a really nice exercise if we did this in real time and shared my thoughts and views with you. Okay, so let's jump in.
We've been fighting a long time, and we have all lost so very much, so many loved ones gone. You are not alone. There are pockets of resistance all around the planet. We are at the brink.
Okay, so the APPG on family separation. The headline here is Better Outcomes for the Children of Separating Parents. Okay, so obviously what I'm not going to do is read through the entire document, but I'm just going to scan through it and pick out some bits that really stand out to me and maybe discuss them, give you my opinion on those. Okay, so the report was published in May 24, so that gives you an idea of how recent it is. One of the most recent reports, as mentioned by Michael in his podcast. Let's look at the top box straight away. This is not an official publication. I'm going to highlight it here. This is not an official publication of the House of Commons or the House of Lords. It has not been approved by either the House or its committees. All party parliamentary groups, APPG, are informal groups of members of both the Houses of Commons with an interest in particular issues. The views expressed in this report are those from the group. So slight red flag for me there already before we've even started, that it's not an official document. It's not an official publication. It's just some research that people have put together showing issues and problems within the family court. The reason that this doesn't give me confidence straight off the bat is that I've read these reports before. I've seen them time and time again. Year after year after year, they all say the same thing, all show the same issues and the problems. They all highlight the same issues and problems, all give options for change, and they all say what needs to change, but does anything ever happen? Does anything ever change? In my opinion, no, it doesn't. So let's see what this report says. Okay, so it starts off with a foreword by Nick Fletcher. Okay, he started to receive requests. Of course, we do not want parents to separate at all as a society. Okay, as we cherish the family unit. So on that, I studied sociology at A level, and lesson 1, module 1, is the family and the importance of the family as a social system and the importance that it has on the individual, the importance that it has on society as a whole. So I completely agree with that. It is painful for parents and, more importantly, the children. The interests of the children must always come first, yet for many the system seems to drive bigger wedges between separating family units. Ultimately, this makes it worse for those children. Okay, pretty obvious. I think we all know that already. I'm delighted to therefore have the opportunity to chair this report, looking at the process, looks at the complexity besides the parents and children themselves, their advisory groups, professionals, professional bodies, government agencies, local authorities, service providers, all involved. Each of these has different motivations and incentives. Yes, of course they do, which may be the part of the reason that change has proved so elusive. I don't think that's by accident. I think that's by design. The central problem seems to be what is essentially a relationship that is treated, though, as it were a simple legal one. Our message in this report, however, is optimistic. The Pathfinder pilot courts in the UK are already proving to be an improvement. Our message in this report, however, is optimistic. The Pathfinder pilot courts in the UK are already proving to be an improvement and are being rolled out more widely. Besides this, there are many positive lessons that we can learn from abroad. Some countries have less adversarial systems. Okay. Now let's look at the contents. Part 1, we've just read the introduction. Part 1 is the problem. And let's look at the headlines or the main bullet points or the main headlines of each topic or each section. Harm to the participants, perception of bias, systematic problems, a vicious cycle, unintentional harms. Okay, I agree with 1.1 through to 4. Unintentional harm, absolutely don't believe that at all. I believe that this system is intentionally set up in this way. People keep referring to the system as a broken system. It doesn't work. I don't think it's a broken system. I think it's designed specifically this way to cause harm to parents, to cause harm to children, with the idea being that let's drive people back into family court to keep the process going because it's a big money spinner. Again, that's just my opinion. Part 2, lessons from pilots, trials and other jurisdictions, learning from UK practice, learning from abroad, shared parenting systems. Okay, so obviously that's going to be talking about the pilots that are in place in the 2 areas. I think they said Birmingham and Wales, where they're testing out these new initiatives. Part 3 is the analysis, the nature of the problem, 3.2, lack of ministerial responsibility. That's a huge one. Lack of ministerial responsibility. Who is responsible for this? There's got to be one person sitting at the top of, I don't care whether it's a group of people, whether it's a board of people, whether it's 1 minister, 2 ministers, 6 ministers, 10 ministers, all sitting on a board. There has to be a single person. There has to be one person that has sign off and makes a decision on this. Who is that person? Why is it not clear? I know there's probably a public facing figure. I think Michael mentioned Andrew McFarlane as that person. Is he responsible? Who knows? Is it one of the ministers? Who knows? Why does nobody know? This is part of the problem, isn't it? Poor data. I don't think it's a matter of poor data. The data's all there. Everyone knows it's there. The data's just been hidden over years and years purposely. I think there's enough data if you talk to people and just look at what's in front of people's noses. I think the problem is that the courts for so long, the family court system as a whole, are just ignoring the problem. So it's not a lack of data, it's a lack of interest in looking at the data. Perverse initiatives on why people are being driven into court. Why are the agencies attached to the court driving people into court? Why are parents going into court? There's initiatives that are there to make it more of interest to them to be able to do that, whether it's a financial initiative or whether it's causing harm to the other parent or gaining control over the other parent and using children as a way to do that. Problems arising from the court process. Problems? Oh, okay. Sorry, that makes my blood boil a little bit. Lack of training. How can there be a lack of training for people that are supposed to be experts? How can there be a lack of training for people that are responsible for my future, responsible for the future of my children for the next 5 years, 10 years, 20 years, the rest of my life, the rest of my children's life? How can there be a lack of training? It just absolutely disgusts me. I've had social workers working on my case that have literally qualified a month ago, and I'm being told by judges that this is a very complex situation, a very complex case, and you give me somebody that's just qualified less than a month ago in their first job taking over this case who doesn't know what they're doing. Makes my blood boil. And again, I don't think it's just a lack of training. I just think it's a lack of wanting to know what the right thing is, or a lack of acknowledging what is probably common sense to the most average person. Proposals. Okay, so they're going to be looking at general improvements, promoting early resolution and out of court settlement, reforming the family court in England and Wales. And then they're going to finish on new routes, implementations. So executive summary. Let's look at the 2 bullet points that they put out at the top. Desired outcomes for the reforms. Number 1, they've said better outcomes for children and their parents. Better outcome for children and their parents. It should be pretty obvious, right? Do we really need research and a report? And I don't know how many thousands of pounds were invested into collating this report and how many highly intelligent people it took to create this report. But better outcomes for children and their parents? Did it take a report and 30 years to be able to come up with that? Well done. Lower costs to both taxpayers and parents. Yeah, lower costs. Or what about no costs at all? That would put a spanner in the system, wouldn't it? That would change the dynamics of parents wanting to drive the other parent into the family courts, and also the need for family courts if there was a lower cost, because people wouldn't be getting paid as much, would they? Let's look at this paragraph here. There is a wide agreement that the process is not working well enough. Far too many parents find themselves caught up in lengthy proceedings, which are costly both to them and to the state, and which have a damaging effect on their children. Part 1, we look at the problems. We've just kind of gone through this. Part 2 looks at the lessons we can learn from both the UK and from abroad. It talks about the Pathfinder courts. So that's where the pilots are being conducted in England and Wales so far. It says here, the current Pathfinder courts are making significant progress, and there exists a range of initiatives to support parents through the process. We look at less adversarial systems, such as those in Israel and the Netherlands, and also the success of shared parenting schemes, such as those in Spain and some American states. Okay, so again, it's pretty obvious that the UK considers itself one of the most forward-thinking, highly intelligent, advanced civilizations on the planet. And yet, for some reason, we can't get something as simple as this correct over other countries in Europe, other countries in the world. It's not something that's done by accident, in my opinion. Okay, so this is just a lot of repetition of what we were talking about before. Part 4, proposal is, however, quite optimistic. Yes, I'd love to see your optimistic proposals. They call it a win-win. We can see these solutions as a win-win. Okay, so if it's a win-win, then it's obvious, right? If it's a win-win for parents, if it's a win-win for children, if it's a win-win for taxpayers, if it's a win-win for government, then it should happen instantly without fail, right? Why? Because you've just said there in your report, it's a win-win, and you guys are advising, have a voice, have a report that ministers in government, in parliament are reading and looking at and should be taking the advice of. My personal opinion on this, it's going to go nowhere. It's going to be ignored. So it's not a win-win. It's just a load of rubbish, in my opinion. Now, I hope that I'm proved wrong in any of my cynicism. I really do. But in my experience so far, and my experience of research over the last 30 plus years, I wouldn't put my money on it. Welcome the process of the Pathfinder course. We propose something of one family, one judge to maintain momentum and save waste time. That's really important. That should be incredibly obvious from the start. I mean, my experience of this is we've gone into court, and every single time we've gone into court, we've had somebody different, whether it's a magistrate and whether it's a district judge. You've got a different person every single time you go in there. And I've lost count of how many times I've had to go into family court for one particular case. Bearing in mind, I've probably had 3 or 4 different cases that I've had to work with. Each of those as a bare minimum will be 3. You'll have an initial hearing, and then you'll have a second hearing where you collate all of that information of what you're going to present. And then you'll have a final hearing, a DRA, where a final decision is made. That's the best case scenario. But in my experience, it's never that simple. You have multiple, okay, let's turn up. What do you want to talk about? Oh, we're not ready to talk. Oh, we've lost this bit of paperwork. Okay, come back in 3 months. You go back in 3 to 6 months. Okay, what do we want to talk about? We want to talk about this. Okay, come back in 3 months and show us what you want to talk about and bring back all the information that we've asked for. You go back in 3 to 6 months. Okay, here's the information you asked for. We don't agree with this. Okay, we'll go back and review it and then come back in 3 to 6 months. And this goes on and on and on and on for as long as the high conflict parent wants to keep arguing and complaining about issues and problems and making changes. And this could go on for a good span of a year until you actually agree, okay, this is the information that's going to be put in before it's even looked at. By that time, you've already lost 9 months of not being able to see your child. It's ridiculous. And then again, you've got a different judge, a different person, and you're trying to have a conversation with them. They're scanning across documents, trying to read them, trying to make sense of what's going on. Clearly, they've literally just read the first page in your bundle or of your documentation, and they will give you some absolute rubbish of a line saying, yes, we've had sight of your personal statement and we've had sight of your paperwork. What that means is they've looked at it. It doesn't mean that they've read any of it at all. I know this because I've had conversations where we've been half an hour through a court case and I've mentioned something on my position statement and the judge has said, oh, why didn't, hang on, I need to stop you there. I didn't realize this. Why didn't you tell me this before? I said, it's in the first paragraph of my position statement, the one that you said that you've had sight of and you've read. Oh, well, this changes everything. Meeting adjourned, court adjourned, come back in 3 to 6 months. It's honestly ridiculous. Right, let's skip through this problem. Let's go straight to part 1, the problem. Again, I'm not going to read through all of this because I think the headlines say more than enough already. 1.1, harm to participants, harm to children, additional adverse childhood experience, enabling alienating behaviors, Okay, and explains what it is there. Of course it enables alienating behaviors. Unnecessary separation, harm to parents. Okay, mental distress. Of course it's mentally distressing. You've been separated from your family, you've lost your home, you've lost everything that you've spent a lifetime building with this person, and the courts that are supposed to be protecting you and your children are doing the complete opposite. Hostility promoted. There you go, hostility promoted. Under the current system, if the non-resident parent wants more time with their child, they need to convince an adversarial court that this is in the best interest of their child. Why should you have to convince somebody to see your own child? What gives that person sitting in that chair the right to say, well, you can't see your child because the other parent has said you can't, so there must be an issue. Increasing suicide. Let's look at this one. Besides the stress caused to both parents, there's evidence that of the 4,000 male suicides each year, perhaps 20% are linked to the relationship breakdown, loss of parenting time with their children. Ads Unlimited, a UK-based charity, reported over 40% of the fathers they do support have suicidal ideation. Of course, when you're separating, or you're trying to escape an abusive relationship, you're trying to walk away from it to gain some peace, you're then stopped from seeing your child as a punishment from the other parent, and then the system that's meant to be protecting you doesn't do anything. Not only do they not do anything, they actively make it worse. That's another topic we'll go into on another solo session, I'm sure. Handling accusations of domestic abuse. Some parents report that the courts do not take their allegations seriously, while others claim the court believes in false allegations. This is absolutely true. They've already picked one side before you've even walked in. And with that, what you'll find is every false allegation that's made, they will believe it or make precautions based on those false allegations without any evidence whatsoever. However, for the person that they're not siding with, no matter how much evidence you provide, tangible evidence, real evidence, evidence that is beyond reasonable doubt, and you provide that to them and show that to them and say, please read this, have a look at this. A, this proves that the allegations that are being made against me are false allegations. And 2, you'll prove that actually the person who's claiming to be the victim is actually the abuser. They will refuse to include that information. They will refuse to look at it. They will refuse to include it, or they will do everything that they can to remove it from the court bundles and the case bundles, and they will then even go so far as accuse you of being abusive for trying to include this information, or say that your information is too voluminous. Again, another topic for another time, which I'm sure we'd like to talk about. So this is interesting here. It references the risk of harm. I think it's the assessing harm report, something that I've read. And again, it was something that I actually planned to do as my first solo podcast, but this one has kind of taken a bit of a precedence. But I will come back to it possibly for the second edition, just so we can see and compare these two reports. I think it's really important to be able to do that. Late accusations, financial cost, loss of contact with relatives. All this is pretty obvious stuff. Perception of bias, systematic problems, legal aid process. Let's look at this. This comes up quite a bit. Allegations of domestic abuse can be used to gain legal aid or prevent the child from spending time with the other parent until a finding of facts. These interim outcomes can be difficult to reverse after prolonged delay and therefore can lead to poor long outcomes for the child. So let's look at that. It's really, really important. First of all, what they're saying is that parents, usually the resident parent, which is quite often the mother, and again, I'm not being sexist here. It's not about men versus women here. It's just a statistical fact that it's usually fathers who are on the receiving end of this. The mother will apply for legal aid by including allegations of abuse because it gains access to funding and money for what they're trying to do. But they will then also make these false allegations to prevent time being spent with the children. And that is to cause harm to the other parent. And it's all there. It's written. It's obvious. This is not new news. This is coming up time and time again. It's in the BBC News right at the moment. Go onto any of the Papa pages, Instagram, Facebook, TikTok. It's all over it at the moment. It's all over the BBC. This is not new news. It's just recycled news that comes around every few years. I've seen it years ago. There was a Panorama documentary on it, probably about a year ago, by somebody called Louise Tickle. She'd also written an article in The Guardian, which I'm planning to talk about at a later date as well. But yeah, this is basically it, isn't it? This is one of the reasons that we end up in court. And this is the reason that parents, fathers are being destroyed by this particular system. Because here it says, there's no spending time with the other parent until the fact finding. So basically, parents are not allowed to see their children if there are false allegations in play. Doesn't matter if you bring all the evidence on day one and go, hey, look, these are all false. Obviously, here's the evidence. Let's forget about this. Oh, no, it doesn't work like that. You have to come back in 3 to 6 months and we'll talk about looking at your evidence. Oh, I've got it here today. Look at it. I can prove. They don't want to see it. So therefore, you've got to wait 3 months at best, 6 months if you're lucky, 9 months on average of not having access to your children, unless the mother says, oh, do you know, yeah, I'm going to let you see the children because I'm such a nice person. I'll let you have one day at the weekend, pick them up for 2 hours and you can take them to the park, but bring them back straight away. I'm doing that because I'm such a good parent. I really care. And I want you to have time with the children. I really do. And the most disgusting part of this is that if we look here, so I'm going to highlight this whole section because it's just making my blood boil reading it. These interim outcomes can be difficult to reverse after prolonged delay. So basically what happens is you spend a year, 2 years in family court. You prove the allegations of domestic abuse that have been made to you completely false. You then prove that you're in actual fact the victim of domestic abuse. You then prove that the other party is in fact the abuser. It's all presented in court. Now, there's a finding, there's a fact finding made, there's a decision made, and you think to yourself, okay, well, yeah, well, the decision's obviously gone in the correct way, but after looking at the evidence, we can reverse all these decisions, right? About access to the child and, you know, who should be responsible for the parent, or 50-50 at least. And then you get told, yeah, sorry, it doesn't work like that. What we're going to do is we've decided to leave as it is. Because it's taken this long, we're going to leave it as it is for the good of the children. Let's look at this section here. High and rising costs of the family court. Family court costs the government $970 million in 2019-2020 in England and Wales, 970 million. So that's close to a billion 5 years ago, right? So what is it now? More than that? Legal aid accounts for 62%, cost of the government, HMMC 26%, CAFCAS, scumbags, 12%. And litigants may themselves spend further millions per annum on their own lawyers and legal costs. So there you go. We're talking a £1 billion system. And in my opinion, that's the reason why things aren't going to change, because of the money and because of the loss that the government is taking. With, it says here quite openly, legal aid accounts for 62% cost to the government. It's a cost to the government. Providing legal aid to people that cry domestic abuse is a cost of 62%. So in my opinion, oh, hang on, judiciary costs 26%. So 26, okay, so we're looking at nearly 90% there. AFCAS, 12%. These are all government paid agencies, right? They're the ones that are taking up a large majority of the costs. Now, the further millions, in my opinion, is their way of recouping that money. And in my opinion, I suggest that it's one of the reasons that they keep driving people back into court, to try and cover these costs and try and get themselves out of the red. Long delays in the system. Let's forget about this paragraph here because it talks about COVID, but the long delays in the system aren't an accident. All they do is they have this long delay in the system. You get to the end, and because it's taken such a long time, as I said before, they'll say, well, it's taken a long time, so we're going to maintain the status quo for the good of the children. That's called the judge's discretion. It's not my fault that it's taken a long time. I could have solved this in half an hour if you look at the correct things to look at. Anyone that's smart or got half a brain cell can look at this in half an hour and decide, make an educated decision based on the information that's provided to them of what's right, what's wrong, what's true, what's false. So it's not an accident that it's a lengthy proceeding at all. High growing number of accusations, domestic abuse, of course, because the solicitors know that if you say certain phrases like, there has been domestic abuse, I'm worried for my own safety, I'm worried for the safety of my children, what that does is sets you on a road of what I consider predetermined results. They know that. So that's what they're going to encourage the resident parent to do. And it's a game. It's a money-making game. I know it's a money-making game because I've seen the bill in my financial hearing. £100,000 plus 6 figures spent on expensive lawyers encouraging parents to make up things and make up false allegations, unintentional harms. Let's look at the unintentional harms. I don't think they're unintentional harms. I think it's designed that way. Parent A is unjustifiably cut off from seeing the other child by parent B. Parent A has little choice but to go reluctantly to family court. And then it talks through the process here. I know this process very well. I'm not going to read it here. It's just going to give me PTSD and I'm not going to be able to sleep. Let's go to the end. Oh, here we go. Exactly what I just told you. The fact-finding can take months or years to resolve. Exactly what I've just told you. I already know this. By the time parent A can show their innocence, the bond with their child is broken. And social services will say things like, well, it's been such a long time now, and let's just, leave as it is because the children are used to their routines. The court may then order that the status quo is maintained. That's exactly what I've just said earlier. Exactly what I've just described. The bond with parent A remains broken. Welcome to my world. Does it really take, I'm going to try not to swear, does it really take a report like this to realize this? I could have told you this years ago. Other people could have told you this years ago. People have been talking about this years ago. Go on YouTube. Go and look back 10 years. I guarantee you, 100%, certainly since I've been doing this 5-6 years ago, there's already been people posting on YouTube and social media, even Trustpilot, talking about their experiences. This is not new. None of this is new. Okay, let's look at this pilot. Section 2, lessons from pilots, trials, and other jurisdictions. Okay, so basically what this is talking about in this area here is talking about this Pathfinder pilots, a kinder and faster process basically based on some of the more successful family court arenas in Europe, as that was mentioned before. And they're piloting it here. Oh, here you go. Birmingham and Cardiff. I hope it works. If it does, I'll be surprised. If they roll it out quickly, I'll be surprised. If it creates change, I'll be surprised. Please prove me wrong. Planning together. Separated parents information. Load of rubbish. They send you on a stupid course with social services who you can't trust anyway. And you sit in a room. The first thing they tell you is, well, the guy that I met, he was one of the very few open and honest people that I've spoken to in this whole process. I've met a couple, but I was talking to him about the information within the training program. And, one of the first things that he said is, unfortunately, guys, usually what we find is that the people or the parents that turn up to these parenting programs are usually the wrong parent. It's usually the parents that are looking to co-parent, and the ones that don't turn up are the ones that don't want to co-parent. And again, why is none of this documented? Why is none of this held accountable or taken into consideration during the process when decisions are being made? It's completely ignored. Completely ignored. No one cares. And the other thing that he told me was, when I told him that the fact finding had gone in my favor, decision and order was made in my favor, we're just waiting for the final outcome. It's looking very positive. I'm feeling really, really good about it. I've just told the truth and presented my case with tangible evidence. He said to me, you won't win. And I said, but I've already got the order and we've had the fact finding. It clearly shows that everything is in my favor. Everything that I've said is true. Everything that the mother has said is false. Surely that will mean that when we go to the final directionals hearing, then things will go in my favor. And he said, it doesn't work like that. Why doesn't it work like that? Somebody tell me. Well, he knew. Big red flag there straight away. Learning from abroad. Okay, so they're talking about different initiatives that they have in Israel, some states of the USA, Netherlands, and they mentioned some other countries here, Portugal, so on and so forth. In essence, what they say, and if you scan through this very quickly, I think the main assumptions are, or the main suggestions are, that for countries where they have a starting point of 50-50 or even 35% and work back from there, then there's less conflict, there's less need to go into court, there's less stress on the parents, there's less stress in the divorce, and there's less stress, more importantly, on the children, their mental well-being. Let's have a look here. I think it says pretty much exactly what I'm trying to say. Sweden, parents. If a decree divorce is granted, both parents shall continue to have custody of the child. In line with active promotion from the government, Swedish courts have adopted 50-50, alternating parenting as the default assumption. Sounds pretty obvious, right? 50% of the child is made by you, 50% of the child is made by you. Seems obvious. Part 3, the analysis, nature of the problem. Family breakdown is a public health, mental health, and distress problem. It's not just a legal one. Okay, let's move on. 3.2. This is a big one, isn't it? I highlighted it earlier in the introduction. Lack of ministerial responsibility. If we ask the question, who in government is responsible for the children of separated parents with unresolved conflict, we find the answer is that responsibility is either spread between departments or in some areas, no one is responsible. How can there be no one responsible? That's baffling. How can there be not one person responsible for the destruction of lives, the destruction of parents, fathers, the destruction of children's well-being, the increased conflict within family courts? How can there not be one person responsible for it? I know, because no one wants the job. No one wants to take responsibility for it. So what they do is they'll spread out the responsibility through a bunch of people, cause confusion, and no one knows what they're doing. And they will say, well, it's a bunch of people. Nobody quite knows. Okay. How long are we going to have this ministry gap? Ridiculous. Or data. I think I spoke about this before. There's loads of data. This is absolutely ridiculous, telling us that there's poor data. There's a lot of data. It's just all being hidden. Everyone knows it's being hidden. I can give you all the data from my court bundle. I've got it sitting over there at the back. Big file like that. I've given that data to social services. I've given that data to CAFCAS. I've given that data to judges. And when I ask, have you looked at it? They say, no, we don't look at your evidence. We make our own evidence. And I'm not paraphrasing there. That's exactly what I was told. And that was recorded in court. It's ridiculous. Now, I can guarantee you 100% without fail, if I were to show you the evidence in my court bundle, and if I was to show you the things and the responses, the reactions, the decisions that are made after or as a result of these court applications and these court proceedings, I guarantee you it's not an accident. It's not an isolated incident. It's something that you'll see time and time again, over and over again, every single parent going through exactly the same thing with the same pattern of behaviours by the same family court system, by the same family court agencies. It's designed that way. And all of the evidence is hidden, usually behind something called a gagging order. It's not by accident. Anecdotes and survey results. How many times do you want to do surveys to find the same information and to have the same results? Just do something already. Risk distortion. Yeah. Risk distortion. Perverse incentives. The incentive to go to court. Yes, one parent is going to have incentives to go to court because they are going to gain control over the other parent. They are going to take all of the finances, the house, the cats, the dog, the children, all of your personal property, take you to court, and then get you to pay for it. That's what the courts do. They say, okay, we're going to give everything to this person because we've decided that they're going to be the resident parent, regardless of who's the victim and who's the abuser. We're going to make that decision. And okay, you make money, so what you're going to do is you're going to pay for all of that. You're going to pay for them to take you to court and spend 6 figures on abusing you, using your children to do that. Public funding incentive, child maintenance, formula used to calculate child maintenance payments. I'm sure we're going to have another long discussion on that. Lack of enforcement. This is ridiculous. When one party breaks a parenting time order, for example, the family court does not enforce its own orders. It does not enforce anything. It will put every order in place to the person that they are looking to villainize. And every time you even cough, sniff, or fart in the wrong direction, they'll jump all over you. But if the person that they are siding with breaks every order and you highlight it and you show them, say, look, you've written in your order, parents, both parents, and it's usually, this is an order that's usually been asked to be put in by the abusive side, shall not engage in certain behaviours. Now, when you prove that the person who put in this order to begin with, and they write it as both parents shall not engage in such behaviour, when you prove that the other parent is doing this, they just completely ignore it. So what's the point in waiting 3 months, 6 months? In the meantime, you're having all of this abuse happening and there's no one there to protect you. And then when you finally get your court appearance, you go in and you say, hey, look, this is what's been going on. The orders that this person has asked for that you've written in your order is being broken. Here's the proof and evidence of it. And they just say, oh, yeah, let's just not look at that and let's just move on, shall we? What do we want to talk about today? Let's be more focused on the children. Domestic abuse and violence are serious matters. Of course they are. Expanded definition of abuse. Okay, this is a big one for me. And again, I'm going to do a whole solo discussion on this. Let me read this because this is going to come up time and time again. As a definition of domestic abuse, DA has expanded to include, for example, coercive control. The potential to accuse the other parent expands as well. There is a lack of differentiation between types of DA, which should result in no parenting time, safe parenting time, and that which has no bearing on parenting time. There is a clear list of what is considered domestic abuse, criminal behaviour, criminal activity. I've gone through it all. I've provided the police, I provided the courts, I provided social services, I provided CAFCAS, all information with tangible evidence, all showing all of this. No one cares. Delay in dealing with allegations. They don't do anything. The current system causes delays and damage. Yes, it does. Well done. First, the allegation is made, then there's a CAFCAS report, then there's a fact finding, further delays in the process, 2 outcomes. Number 1, let's look at this. Courts are reluctant to order a fact finding to cause delays, costs, etc., because they can't be bothered. Or 2, the accused parent, often the father, can lose parenting time with the child while the whole process drags on, sometimes for years. I don't know what the vested interests here, but I've just seen CAFCAS here saying, CAFCAS, and those offering services, domestic abuse victims, providing service to parents, all derive their incomes from the current system. First of all, they do not provide support to parents. In my opinion, this organisation is a tool of the family courts to create more conflict. It's just done there purposely. Why? They've said it here. They derive their incomes from the current system. So if they create conflict, by false reporting, which they do, and you can quote me on that. Yes, they do. They make false reports to create more conflict, to empower the high conflict individual, which means that the high conflict individual will continue with their bad behavior, encourages it. The non-resident parent, often the father, will then say, well, hang on a minute, this isn't right. This isn't true. Well, if we seem to have a difference of opinion here, if you're not happy with our opinions, then you do have an option, and that option is to discuss it in family court. We will direct you to the family courts. So they're all working in a triangle, basically. 1, avoiding taking responsibility. 2, driving you back into the family courts. 3, the money aspect. Lack of voice in the child. Yeah, I get this one. They completely ignored all the wishes of my children, even though that's part of the welfare checklist. Access the charge, best interest of the children, best interest of the child. This drives me insane, this phrase. You'll hear this all the time. Here we go. What does this say? This is going to make my blood boil, just the title alone. Well, this is enshrined in law. There is no definition of what the best interest of the child means. It's left to the court to decide, making the term almost meaningless. Almost any judgment can be justified by claiming it is in the... Sorry, I'm going to try not to swear here, because let me finish reading it. Almost any judgment can be justified by claiming it is in the best interest of the child. A definition is needed, which includes maintaining safe parenting time with both parents. Sorry, it's that line that really triggered me. Almost any judgment can be justified by claiming it is in the best interest of the child. The amount of times I've seen judges make unlawful, criminal, and CAFCAS officers and social services officers unlawful, criminal, not in line with their orders, not in line with the orders that are right in front of them, not in line of the best interest of the child, not in line of the best interest of the family, not in line of the best interest of anybody involved in this. They will end it with, we make this decision for the good of the children, in the best interest of the child. We'll make this decision. And again, they will use tie downs, such as, you do want what's in the best interest of the child, don't you? Yes, of course I do. Okay, fantastic. And then they just ignore you and carry on writing, in essence, what they were going to do anyway, which is absolute rubbish. It's disgusting. I'm glad this is highlighted here. Lack of standard practice. There is a standard practice. The standard practice is absolute rubbish. I know what's going on exactly. I talk to people. I've seen with my own eyes and my own experience. Here we go. The adversarial approach. It's an adversarial system. Makes it difficult for family courts to promote reconciliation or dispute de-escalation. This whole process has just made things 100 times worse for me and my family, me and my children. There's absolutely no way of reconciliation after this. Absolutely none. How can you reconcile with another person that has done this to you and driven you through this family court process because they've probably been advised by very expensive lawyers that this is the best thing to do because if you say this, then you'll get this. It's obviously what's happened. Let's look at this bit here. Mothers complain that allegations of abuse are not taken seriously, and the father allows fathers to make claims of parental alienation. Now, I can't speak for the views of mothers and their experience because I can only speak from mine and the people that I talk to, and it's usually fathers that I come across. However, in my research, I have been coming across more and more mothers that have been in this position or for other reasons within family court that have been put in this position. So I know it does affect them. But like I say, the 9 times out of 10 is going to be the father who's the non-resident parent, who is having the false allegations being put towards them that they need to address. Fathers complain that the court takes false allegations of abuse so seriously that they lose parenting time with their parents for no good reason. I don't think they even took them seriously. They just say, because there's been an allegation, the next thing to do here is just to stop all contact for the good of the children until we're able to investigate this. Doesn't matter whether you can say, well, I've got all the police reports here, I've got all the evidence here that proves all of these allegations are wrong on day one. They will not want to look at that at all. It can be looked at within 10 minutes and go, yeah, okay, this is absolute rubbish. What the allegations are, I can see that straight away by looking down here. They will just say, well, let's come back in 3 to 6 months and talk about what we want to talk about. And then when you come back, we'll talk about what we want to talk about a little bit more. In that time, you're just losing time with your child. Okay, let's skip through some of this. Lack of training. Section 3.6. Lack of adequate training for professionals. I cannot understand how there can be a lack of adequate training for judges, for CAFCAS officers, for social services, social workers in this complex system. I'm not going to read through all of these, but the obvious ones here: child development, including attachment, relationships and their breakdowns, mental health diseases, personality disorders, traumas and its presentation. How can you expect a social worker who has qualified a month ago, who is looking at your case saying, we don't really see a problem here, even though, again, anyone with half a brain can look at the behavior of another person, see the patterns. I've even been there and said to my social workers, I said, watch on this date, this will happen. Watch on this date, this will happen. How do you know that will happen? Because there's a clear pattern of behavior and I can predict the day that this is going to happen. Oh, no, that's not possible. What happens? Bang. Well, how did you know that was going to happen? Because people like this have an uncontrollable pattern of behavior. It's easy to predict. But yeah, they can't even see it. If you point it out to them and if you try and educate them and try and show them, they either dismiss it, say, oh no, we've got experience in this. Yes, we're very experienced. And you go, okay, well, what signs do you see? What patterns do you see? I can't really answer that. Or they just outright admittedly say, no, I don't have any experience in this. Well, if you've got no experience in this, how can you make the decision to say that that child is safe? How can you do that? Because you can't even recognize the basic signs of an abusive person. Half the time, these social workers look like they're not even old enough to be married, let alone have children, let alone have been in a relationship for a long term that's been an abusive one or had to experience that. You've got quite often a wet behind the ear 22-year-old who is in charge of deciding the rest of your life and the rest of your children's life. It absolutely disgusts me. Let's move on. Proposals. Here we go. Final section, part 4. The child's welfare should be the court's paramount consideration. Again, this just annoys me. Section 1 of the Children's Act 1989 sets out its general principles. Let's look at that first point straight away. The child's welfare should be the court's paramount consideration. It's not. This is an act from 1989. The Children's Act 1989. What are we in now? 25. This has been going on since 1989. The courts don't care. The judges don't care. They're going to do whatever they do. It's already documented in this report. All they need to do at the end of doing whatever they want to do is end it with the exclamation point of, we're doing this for the good of the children. And that's it. Primary objectives: to promote positive outcomes for the children and the families involved, to reduce financial costs to both parents and to the state. Now, if this happens as the primary objective, I will eat my hat. I will dress up as Spider-Man and I'll climb the Tower of London, whatever. I don't see it happening. It should be happening. It should have happened years ago. It should have happened a year ago, 5 years ago, 10 years ago, 20 years ago, 30 years ago. It's the same story over and over again. And that's one of the reasons that I'm doing this podcast, to highlight that. Because once we start collating these stories, all we're going to see is the same information, the same stories, the same excuses, the same reports being written over and over again. But what I want to do is I want to collate that all in one place. All of the thought leaders, let's get them together. Let's educate people and say, look, this is not new. This is not a new report. This is a recycled report from something done 5 years ago. Again, I'll show you that report that I referred to earlier, the Assessing Harm report. Continuing research and reports. Let's look at this final part here. The current system is high cost and low satisfaction. The proposals are a win-win. Okay, but it's a win-win, then it should be a lock, right? 100% reform coming. Are we ready? It says it's a win-win. It's going to happen. Yeah, right. Win-win my ass. General improvements. A responsible minister. How about just a minister? You've already said in the report here there's not one minister in charge of this. In total, at present, family breakdown spans 14 departments. Again, it's not an accident. It's not an accident. It's just a way of avoiding taking responsibility and causing confusion with who people should talk to and who this should be raised with. Because if there's not one person to raise this with, then that confusion just causes the chaos and people don't know what to do. And eventually they get bored of going, oh, well, if you fill out this form and fill out this letter of complaint, we'll assess it. You fill out that form. Do you know what happens? You get another form. You have a phone call, somebody saying, oh, yes, we got your form. Thank you very much for filling out that form. Here's another form. Can you fill out this form? And you get another form to fill out. You fill out that form, you send it in. A few months later, you get a reply saying, yes, sorry, we can't help, but if you're not happy with our response, then you can fill out this other form. Call the ombudsman. Think, all right, I'm going to get somewhere here. The ombudsman, finally, they can sort this rubbish out. And look at the bullshit that's happening. 9 months later, get a response from the ombudsman. Sorry, we've received your letter, and unfortunately, there's nothing we can do to help. This case is now closed. Yay! So that's the trick. Keep sending people in this endless loop of filling out forms. One person might get bored. One person might get bored before filling out the first form. Another bunch of people might get bored before filling out the second form. A bunch more people aren't going to pay for the ombudsman and go to their MP to get sign-off for it, fill out all the forms and then send that off. A bunch of people aren't going to bother doing that. I did all of that. I followed the process, exactly what was asked of me. And it goes nowhere. It goes absolutely nowhere. That's not an accident. You just get the response. Sorry, there's nothing we can do. So what was the point in filling out all these forms? Reliable research evidence. Again, I don't buy this at all. I'm not buying this. If you want reliable research evidence, just open your eyes, talk to people, allow people to tell you what's going. You don't even need the research evidence. You've got all the evidence you have. Okay, so again, and we've got the final section here. General improvements, responsible minister, reliable research evidence. These are all the research places where they found their evidence, I guess. Invest early, information and support, hub for parents, national website. Do you know what we really need is a national hub of transparency where people don't have to fill out forms and pay to fill out forms and pay to get the transcripts for what is going on in the courtrooms, because the large majority of people can't afford to do that. And the courts know it, so they can get away with all of their criminal and unlawful behaviour, engaging the children. Yeah, that works depending on how much the resident parent has alienated that child. Central Justice Report, training for professionals, we've looked at that already. Better definitions, a wider view of safeguarding. Okay, so this is just kind of like a recap. I think this is a good part here, family aid rather than legal aid. Reduce the child maintenance incentive. Yeah, this is a very good one here, because I find that resident parents are often playing the game of, well, if I make something up about the other parent, that'll give me more time with them, that'll give them less time with them, that'll mean I'll get a higher pay in CMS, in child maintenance. It's obvious. Again, it's not an accident. Less adversarial approach. Okay, so we're just recapping here. Let me pick out a couple to end on here. I'm going to pick out promotion and mediation. Waste of time, doesn't work. They don't promote it at all. They say, we suggest you go to mediation, and then when the other person doesn't turn up, if the other parent doesn't turn up, there's nothing to enforce them turning up. The judge will say, well, why don't you just try again and come back to me in 3 months or 6 months' time? And then you can get locked in this cycle for another year, just going around in that circle. It's an absolute waste of time. Rules-based system. The rules are ridiculous. It's rubbish. You've got practice directions 12J, which is like the Bible of being in the family court, and you can follow that word for word. And again, the judges, the courts, the social workers, CAFCAS, they will just interpret those directions however they choose, whenever they want, however they feel on any particular day, to whatever suits them, and ignore every time you try and reference them. Let's look at this. This is the big one. Shared parental responsibility as a starting point. Yes. One family, one judge. Yes. Maintaining parenting time. Yes. Reduce delays. Yes. Roll out Pathfinder. Okay, we'll see. Improve enforcement. Yes. Part 5, new routes for separating families. I've gone through that, and I think my final thoughts on this are that I don't see anything new. I don't see anything new in this report here, even this last part here, overcoming barriers to reform. Why are changes not taking place? We've identified several reasons. It's a system problem. Everyone knows that. It's systematic. It's systemic. Hang on a minute. Each member of the team, whether family solicitor, CAFCAS officer, court official, judge, social services officers, are all doing their job. It is not staffed by evil people trying to destroy families. I really disagree with that. 100% is staffed by evil people trying to destroy families. And yes, they are all doing their job. but they're all being paid to do that job. They're all being paid to create conflict. They're all being paid to write false reports. They're all being paid to act in unlawful ways. They're all being paid to act in criminal ways that destroy families. But here it says, it is the system they're part of, which they are, as individuals, have little or no control. Quit your job. That's what I would do. I've been hired by companies where I've gone in and I've been told to mislead customers, clients with false information about the technology, the product, this, that, and the other. Do you know what I do? I pack my bag and I walk out. I say, yeah, not for me. Why? Because I'm an honest person and I'm not just doing my job. I don't care how much money you want to pay me. I'll walk away. And it's funny that you'll find there's such a high turnover rate of social workers and CAFCAS officers, most of them not even making a year. And that also tells a story to me. What about the ones that have been there for 5 years or more, 10 years, doing their job? What types of people are they? You tell me. Right, I think I'm going to leave it there. I think I've gone through a lot of the things that I want to go through. If anybody is interested in finding this report, if you just Google this headline that's at the top here, Better Outcomes for the Children of Separating Parents, or type in APPG on family separation, you can find it on a Google search. I'll put it in the link below as well of this. I hope you find this in. Tell me what you thought of this particular style of discussion. Do you find it informative? Is it annoying me sitting here and running through it with you? Do you find it interesting? Would you like more of this? I'm hoping to do more of these. I find it really interesting for me because there's a lot of information that's out there that people are unaware of. And it's shocking that this information is available, but people aren't told about it. People don't know about it. So let me know your thoughts in the comments below. Drop me a line, drop me an email at me, repost, retweet, do anything that you can to raise awareness of this particular report. Hopefully this is the first of many thought leadership discussions. As I mentioned before, thoughts and views are my own, and I've tried to maintain some sort of level of decorum. Hope I was able to do that. I didn't say any words like fuck or bollocks, which I could have done at many times throughout this and wanted to. So I hope you guys have enjoyed having a look through that with me in real time, having a read through it. If you did, let me know in the comments below, drop me a line, drop me a message. Let me know what you thought of this particular podcast. Let me know whether you thought of this particular session. Does it work in an audible format? If you're listening on iTunes, if you're listening on Spotify, let me know if it was easy to follow. I'll be listening to it myself and seeing whether it made sense. I hopefully will be doing some more of these types of sessions. If anybody has any ideas of the types of things that you'd like me to cover, please share them with me. I've got some ideas of many things that I'm planning to cover already. But like I said, let me know your thoughts. As always, I'd like to end with my final message. My final message is, you are not alone. Stay strong.
If you're listening to this, you are the resistance.